we would like to thank Professor Eric Mack for returning for his second and final lecture of the seminar. And this lecture is titled Property Rights. Professor Mack?
Great, thank you very much. So this lecture is a companion to my previous lecture on natural rights. In that earlier lecture, I discussed the case for human freedom from the perspective of moral rights, especially talking about a really basic natural right to freedom. In this lecture, I'll discuss the case for property, especially private property rights, from the perspective of moral rights. You'll recall that in the earlier lecture, I talked a little bit about specific property rights, and I mentioned them as one of the two main categories of acquired moral rights. So we're going to be talking about that. A good theory about property rights will not always, or even maybe most of the time, confirm the actual holdings that people have. Sometimes a good theory of property rights will probably tell us that some of the holdings that people have, some of the things that they have possession of, they rightly have possession of. But one should also recognize that a good theory of property rights might show us that all sorts of holdings that people have are not in fact legitimate. And I think we live in a world in which we have a mixture of legitimate holdings and non-legitimate holdings. This lecture is divided into 4 sections. The first focuses on Locke's famous account of the origin of initial property rights. The second section focuses on what Robert Nozick calls end-state theories of distributive justice and pattern theories of distributive justice. He has a variety of very interesting arguments against both of these types of theories of justice. I'm going to just talk about, in some ways, some of the simplest, in some ways, the simpler of those arguments. I might mention as we go along where you can go for a discussion of the more complicated critiques that Nozick has. So that's the second part. The third part of the lecture will spell out a little bit Nozick's own conception of justice and holdings, and that's what he calls his theory of historical entitlement. And I'll try to put some emphasis on in what way this type of theory is different from the theories that he criticizes, and what the intuitive virtues of that sort of theory of justice and holdings is. When we're talking about justice and holdings, we're talking about property rights. So the third section is on Nozick's theory of historical entitlement, that particular conception of valid property rights. And the fourth section, I revive a notion that is barely present in Locke. You have to look really, really hard to find it in Locke. And it's not present at all in Nozick, and that is the notion of a natural right of property. And I'll mention right now that if you go back and look at the writings of people like, well, George Mason, who was so gracious as to lend his name to George Mason University, you'll see he talks about the natural right of property. And it's a little puzzling just what that means, because property rights per se, particular property rights, are required rights. In that sense, they're not natural rights. So what could the natural right of property be? And the last section, the fourth section of the paper, is about that topic. We're on the first section on Locke, on his famous labor theory, labor mixing theory of just initial acquisition. Probably all familiar with this, but I want to go through it and give a sort of sympathetic reading to Locke on this. You'll see as I move along, I'm thinking that this doesn't do all of what a good theory of property rights needs to do. So political theorists in the 17th century and before, but especially in the 17th century, or increasingly, were concerned about questions about the origin of valid private property rights. There were two views. There were obviously many, many views, but two of the dominant views went this way. One said, originally, in any given country, wherever there was a political sovereign, that sovereign was the baseline owner of all natural stuff. So the sovereign owned the land, he owned the fields, he owned the forest, he owned the ore, he owned the wildlife. And the only way a subject could become a property owner in any segment of that was for the sovereign to grant that particular individual a right to this field, this river, the animals that were living in so-and-so forest. The other view, or another view, probably the second most common, was that the people as a whole were the original owners of the earth, of land, where land was understood as all raw material. Okay. So these are the two views that Locke was concerned to reject. Locke had a lot of arguments against these, but his main argument was, if all raw material belongs to the sovereign, or all raw material belongs to the people at large, then no one will ever be able to do anything to achieve their own happiness or self-preservation except by permission of either the sovereign or the people at large. You'll have to go hat in hand to the sovereign or hat in hand to the people and say, please give me permission to pick up this acorn so I don't starve to death. And Locke thought that it was that, in effect, the view that everything belonged to the sovereign or everything belonged to the people at large meant that there really couldn't be a natural right of self-preservation, a natural right to seek one's own happiness. Since he thought there were those rights, he thought it couldn't be true, that the land was originally owned either by the sovereign or by the people at large. So Locke concludes that although he says God gave the earth to mankind in common, what that really must mean is simply that God made the earth available to everybody. The earth is there, it's essentially unowned, it's within people's rights without asking permission of either the sovereign or everybody at large to use the land, and not just to use it, but to consume it, to acquire it. And one example he says is, look, how do you use an acorn? You can't just use an acorn. You could throw it up in the air and catch it, but if you're going to eat it, right, you're not just using it, you're totally acquiring it. If you're consuming it, total acquisition. So people must have a right to engage in the use and acquisition. The crucial question is, how do people get the right to any particular thing? And as you all know, Locke has argued earlier in the treatise that people have a right not to be subject to being killed, to being maimed, to being locked up, to being enslaved. All of these sorts of actions are naturally perceived as trespasses against the person. And for Locke and for other people at the time, a natural way of explaining why we call all these things trespasses is to say, well, it must be that people have something like a property right in themselves. Locke talks about each of us having a self-proprietorship, right? A type of ownership of ourselves. And this is the doctrine that Locke is going to make use of in terms of his argument for property. If we have a right to ourselves, we have a right to our labor, Locke says, and if we mix our labor or we annex our labor to a bit of raw material, he says we become the owner of the resulting object, right? Not exactly the owner of the raw material, because the raw material has been transformed in some way. And what you become the owner of is the transformed object. A lot of people read this in a very unsympathetic way. They pretend that Locke must have meant something like you add 10 ounces of your labor to 10 pounds of some raw material, and now you have property that weighs 10 pounds and 10 ounces, right? He didn't mean, he couldn't have meant mixing and annexing in that literal sense. Pretty clearly what Locke was talking about, although he didn't have this vocabulary, was the idea of human capital. If you're a self-owner, then you own your human capital. You know, you own your physical and mental faculties, you own your energy, you own your talents. And what we do when we take hold of some raw material, which in no way belongs to anybody else, and shape that raw material for the sake of some ongoing purpose, is we invest that human capital in the resulting object. Okay? And Locke thought, seems very intuitively plausible, that if you have done that and now somebody comes along and grabs that object from you, doesn't have to physically attack you, but grabs the object without your consent, then that person is making off with the human capital which you have invested in the object, which you still have a right to in virtue of your self-ownership. That's why the person making off with the object that you've created violates your rights, and that's why it's reasonable to talk about this object as something that you have a property right in. Okay. So that's Locke. I'm going to move on to the second part of the lecture, end state principles, patent principles, and some of their problems. Okay. These are terms that Nozick employs in Anarchy, State, and Utopia. I want to try to say a little bit about what he means by an end state principle, what he means by a patent principle, and talk pretty briefly about some of the really basic, not very complicated problems that principles of these sorts have. Nozick wants to talk about these principles, partly in order to get rid of them, and then the doctrine, his own doctrine, can be brought forward as, look how different my doctrine is. Look and see how my doctrine doesn't have the defects of the views I've just criticized, and so don't you want to embrace my alternative doctrine? Okay. So I'm going to talk a second about what end state theories are, and then talk a little bit about what pattern theories are. Both sorts of theories say that what one ought to do in thinking about justice and just holdings is imagine all the different ways that the stuff we want to distribute, let's imagine that the stuff we want to distribute is well-being, right? Or to make things simpler, let's imagine the stuff that we want to distribute is income, right? And we think if people get income, then they'll achieve a certain level of well-being. So our problem to create a just world on both an end state and a patent position is we've got to think about all the different ways that the stuff we want to distribute, let it be income, we have to think about all the different ways that income can be distributed. We have to look at all these different possible alternative distributions, and then we have to pick the distribution that is best, or is, for some reason, should be described as just. Now, I wonder if I were to hold this up, piece of paper, no, oh, maybe. So maybe you're seeing a little bit of a table there. I'm now going to try to describe the table. Let me just put it this way. Here are the three most obvious end state views. An end state view says, you just show me the numbers of different income that different parties would receive under the various different possible alternatives. You just show me the numbers and I can tell you which row, which distribution is the best one. So imagine you're an egalitarian end state theorist. You'll say, show me all the different distributions, different possible ones. I know that the one that is most equal, where what people end up with in terms of, say, income, is most identical across people. I know that whatever the other numbers are in the other distributions, the distribution that is most equal is the just one. Somebody else, a utilitarian or aggregationist, will say, yeah, show me those numbers, and I can also tell you which is the just. I will add up the numbers across, give each possible distribution, and the possible distribution where the numbers add up the most, where there's the most income, well, I can tell you that that's the just distribution. The advocate of the difference principle, Rawls's famous principle, will say, no, you're both wrong about what arithmetical feature you should look for. What you should look for when you look across different distributions is, let's find the distribution where the smallest amount that somebody gets is more than the smallest amount than somebody gets in any of the other distributions. Each of them thinks that by just looking at these possible, the numbers of the available distributions, we can determine which of these distributions is the best or which is the just one. Now, how can I put this gently? This is a crazy view. It's really a crazy view. Because, for instance, it might be that all of the distributions that you're looking at that are available are far inferior to a distribution that would have been possible, except for the fact that one of the people that we're going to be distributing to has gone on a destructive rampage and destroyed lots of resources, lots of equipment, and so on, right? Surely that fact, which doesn't show up on the table, has got to be highly relevant to which of these distributions one should choose. One shouldn't choose of the remaining available distributions the one in which that person does better than he does in any of the other distributions. If that person is responsible for the available distributions all being radically inferior to what they would have been if he hadn't been destructive. I'm just going to use that example. What that example shows is that it can't be that we can decide which distribution of income among the available ones is the best or the just one by only looking at the numbers that are in that table. I'm going to try one more time just to see. That is, oops, that's the table I'm talking about. Okay. So that's a criticism of end state theories. Pattern theorists are not quite guilty of the false supposition that we've just talked about. A pattern theorist says, no, we do have to know something about the world outside of just the numbers that appear in this sort of a table, right? If you are thinking about choosing the most equal distribution of income, that's got to be based upon there being some equality among the people out there in the world to whom we're going to make the distribution. So, for instance, someone might say, we should distribute income in accordance with moral virtue. Hayek talks about the theory that income should be distributed according to moral merit, right? He doesn't endorse it, he rejects that theory, but he talks about it. Okay? So we have to go out into the world and see, is moral merit equally distributed among people? If it is, we should pick the distribution of income that is most equal. Is moral merit distributed in some other pattern? If so, we should pick the available distribution of income that most matches that pattern. We want individuals to receive in the way of income in proportion to their possession of the feature that we're trying to track, whether it's moral merit or aesthetic sensibility or political loyalty or reliability, or maybe even sometimes some people will talk about distribution should match productivity, and that's a complicated thing to talk about. Okay. What the obvious problems with this sort of a theory, take moral merit, which is more plausible than aesthetic sensibility, is that it's very hard to know what the distribution of moral merit is, right? And any attempt to find out what people's real moral merit is would involve recruiting their families and their friends to report on them regularly and having a board of assessment of moral merit, kind of like the assessment of your house value. And it looks like a pretty awful and unworkable project. Okay. I want to mention only one other problem here, and it's a simple problem, but a problem for both end state theories and pattern theories. Looking at my time situation. I believe I have a little more time because we started late. Very quickly, this is what I call the big social pot problem. The sort of theories that we've been talking about assume that somehow what we have to distribute has just been brought into existence. In the income, there's a flow of income, right? Where did that total flow of income, or where did that total social product come from? Who produced it? Who had to do what? Over what length of time did people work? Who did people work with? Did they work with people voluntarily, or were some of the people enslaved? None of that. Something must have happened that produced this product. But justice is not concerned about how the problem of production has been solved. The only thing that justice is concerned with is, well, we've got the stuff now, and it's up to us to decide how to distribute it. This seems to be a strange thing, right? To think that what went into the production, people's efforts, people's arrangements, whether the arrangements were morally acceptable or not, none of that has any direct moral relevance to how things now should be distributed. Right? Sometimes this is described as a type of manna from heaven view. We just treat the stuff that we have, the wealth, the flow of income, the total social product, as though it's fallen down from heaven. We don't think about where it came from. Nobody gets credit for having produced this or that or engineered a new way of producing things. Our problem is solely, how do we distribute it? Contribution on such a theory doesn't itself matter at all. The only thing that matters is recipients. The only thing that matters is, what will we do to enable people to consume? Those are things, and I think that that's not a good, that's a very unattractive feature. Very, very quickly, I've got to move super fast. Jason, I'm sure you're hearing me, and strike me down with a thunderbolt if I go a little bit longer, but I think we started late.
Sure, that's fine, Eric.
No, okay, good, thank you. Okay, so Nozick gives a whole bunch of other arguments. I'm going to recommend that if you want to see the more complicated arguments, you can look at an article by somebody, me, in the Stanford Encyclopedia of Philosophy on the political philosophy of Robert Nozick, and I try to give an account of these more complicated arguments. As I said earlier, Nozick thinks that his historical entitlement view, that a good deal of the plausibility of it is precisely that it's so deeply different from end state and patent views. Well, what makes end state and patent views so troublesome? It's just the thing I was talking about, namely that we don't pay attention to the processes by which income or wealth or the means to make people happy have come into existence. We pay no attention to that at all. We just treat all of this stuff as given, and then willy-nilly we have to figure out how to divide it. They're outcome-oriented, and this is the problem for Nozick. Well, how do you get a theory that is not outcome-oriented? You get instead a theory that is process-oriented. Okay? So a process-oriented theory says whether or not somebody has a just claim on some holding that they have is fundamentally a matter of the processes by which the person came to have those holdings. And also, we can look at somebody who has some holding and say, did that person get this holding by the appropriate sort of processes? If not, it's not a legitimate holding. Right? So if I have a nice shiny silver dollar, someone says to me, how did you get this? I say, easy. I saw somebody walking down the street. They had this nice dollar. I hit him in the head and took it, right? The problem with my having that shiny dollar is not that it doesn't fit some distributive norm. It's not that I have a dollar and somebody else doesn't have a dollar. The problem is the way I got the dollar. If instead I say, well, you know, I've got this shiny dollar because I saw it and I said to somebody, I'll give you a nice lecture on property rights if only you give me the dollar. We strike a deal, I give the lecture, he gives me the dollar, right? If the right processes go into your possession of something, you have a moral right to what you've come to possess. And your right to what you have come to possess is completely independent of the issue of whether or not your possessing it fits into some pattern or some end state that somebody else, a distributionist-minded person, thinks ought to exist. I just want to emphasize here how Nozick's sort of story is the story we normally ask. You see somebody walking down the street again. You notice they have this shirt. For some reason, you're not so sure that they have a just title to the shirt. So you say to them, is that really your shirt? Is it really your property? Person says, well, you know, it is because I bought it from Amazon. And Amazon bought it from these nice people in China or Vietnam. It's a nice process, which results in my now having the shirt, and it's because of that process. And if somebody says, no, 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 my question is whether or not when you have that shirt, it contributes to there being an equality of shirts across the world. Normally we go, no, that's not the issue. The issue is, did you get it in an acceptable way? We have to focus on process. And there's a strong, strong classical liberal and libertarian tradition which says it's the processes that matter, right? It's not whether slavery makes people, produces more misery than happiness. It's the processes that you have to inflict on people to institute slavery that matters. So slavery can matter negatively, and process can matter negatively or positively, but that's what we have to focus on. How do you create a just world according to Nozick? You don't create a bureaucracy that with the power to produce equality or the power to produce the maximum income across society, or the power to produce or try to produce people having income in proportion to their moral merit. The way you create justice and holdings is you let people be free to follow justice conferring, entitlement conveying, or generating processes. And what people end up with when they follow those processes are their just holdings, irregardless, if that was a word, without regard to whether it creates or doesn't create somebody's view about what the right distribution should be. Okay. Last thing, which I'm going to try to do quite quickly here. Yes. So this is the section on the natural right to property. Only take a minute. Super condensed. I started this talk with a little sympathetic account of Locke's labor mixing account of initial just acquisition. And according to that account, property rights emerge out of self-ownership. Having planted a bit of myself, my human capital or my labor, in some natural material, I extend my self-ownership to that resulting object. That's basically Locke's story. Okay? What I'm talking about now, what I want to talk about now is a different natural right. And so I'm talking about a type of classical liberal or libertarian theory of rights that departs from the idea that the self-ownership right is the single fundamental right. I think there's several other fundamental rights, and this natural right of property is one of them. Okay. I don't think that all acts of just initial acquisition can be shoehorned into Locke's labor mixing shoe, nor can you do this for just transfer. I think a good general account of the acquisition of property rights cannot be built on the labor mixing model, even though some just acquisitions fit that picture. What else needs to be brought into the picture? I think it is the natural right of property and the ways that that right is concretized within actual functioning societies. I think you'll see what I mean pretty quickly. Human beings need to have security in themselves and in their discretionary control over themselves if they are to live free lives. And this is the basis for ascribing to all persons a right of self-ownership, which, by the way, we should notice is the core premise in arguments against all sorts of paternalistic and moralistic interventions. However, for people to live their own lives, it's also crucial that they be able to attain secure and discretionary control over objects in the world, over shirts and laptops and fields and tractors and so on. For almost all of our ends involve bringing about some state in the external world, and almost all of our efforts to bring about those favored states of the world require the use of worldly needs. So just as individuals must have a natural right of self-ownership, they must have a right to make external things their own and exercise discretionary control over what they have made their own. That's the natural right of property. But here's a complication. The natural need of people to be able to make things their own and exercise discretionary control over what they have made their own, the natural need for people to be able to do this exceeds what we might call the natural means of making things one's own. For instance, labor mixing, which is a natural means of making things one's own, but there has got to be other ways of making things one's own if people are going to have extensive rights to make things their own and exercise discretionary control. Consider this pretty simple example, initial property rights to pan gold along a stretch of a stream. There is no one particular natural way to establish such a right. Some processes seem to be naturally inadequate, like declaring from 500 miles away that one has the right to pan along 500 feet. I'm in Kansas City and I say, yeah, there's a stream in Colorado, and I claim the right to 500 feet of that for painting. That doesn't seem like a plausible or acceptable way. Other processes seem more eligible for establishing a right like this. For instance, panning along the stream for 5 days out of a week for several weeks, or clearing the brush along the stream to facilitate panning for gold, or putting up markers of a certain sort, right? Maybe that process will work to establish a property right. Which of them will work and why? Well, what will make one of those processes or a couple of them work and others not is simply that process or those two processes becoming the conventional way in which you establish that sort of right. People come to understand that this is the way this particular type of object becomes owned by people in this area. And it's a matter of people understanding that this is the expectation. When miners got to places which were blessedly free of governmental authority, they didn't start killing one another about panning rights. They developed conventions and customs about what would count as a way of establishing your right. Right? These are artificial in a sense that a philosopher can't deduce what are the right ways or the established ways of establishing such a property right. These emerge from people's interactions and the fact that people need to create ways to establish such rights because the establishment of property rights is so crucial to people living well. Quick final couple of paragraphs. Conventional rules arise to overcome the shortage of natural rules for the establishment of property rights. A broad body of such rules for just acquisition and transfer, which is coherent and readily understood and serviceable for resolving disputes, vastly increases our ability to make things our own and to exercise discretionary control over what we have made our own. The natural right of property is the right that each person has, that others respect the ownership that he or she has established through acquisition in accordance with these rules. Although the particular rules may be conventional, what gives them their moral force is that compliance with those rules is the concrete way in which people respect one another's natural right of property. Last couple of sentences. The natural right of property is not a natural right to this or that chunk of stuff. It's not a right to this or that share of stuff. Any right one might have to a particular chunk or share of stuff has to be an acquired right. Rather, the natural right of property is the right to engage in processes which by nature or by convention make things one's own and make it possible for one to exercise discretionary control, as long as what one does in acquiring those things does not violate other people's rights. Just as the right of self-ownership is crucial to serve the possibility of people living their own lives well, so too the natural right of property is crucial to serve people living their own lives well. This is the natural right of property again, and it appears here as it appeared in many classical liberal writings where we see the Trinity presented, the natural rights of life, liberty, and property. Good. Thank you very much.
So the first question, what are some examples from our own everyday life of just original acquisition?
Very few now, right? I mean, ones that we have examples, but they're examples that actually occurred a long time ago, right? So there are places in the world. I'm a big fan of Life Below Zero and these sorts of reality TV shows. Those people actually do engage in original acquisition. So that, as a Lockean, sort of a Lockean, I like. But most of the original acquisition that we now benefit from took place a long time ago. And part of the question, I'm sure, is what if those original acts of acquisition were not just acts? And I don't have time to even try to address that. It's a serious question, but I think it requires a discussion of how much information you have to have now to undo a current possession on the grounds of something that happened 50 years ago, 100 years ago, 500 years ago. And it may very well be that there's simply, although we know in general there were great injustices done, and that has to have affected the way the world is now, we can't disentangle all that stuff. And so often the fact that the last 3 or 4 moves in the possession of something were legitimate moves has to be for us enough to accept the possession as it is. Nozick once said to me he thought he wanted to come up with a theory of the half-life of historical injustices, but he never turned his attention to it.
Good. That's actually the next question. So even if we don't have that half-life,
right,
what are the considerations that would go into thinking about when reparations might be needed and when they simply go back too far?
Yeah. So if you get to the injustice quick, obviously, that's infinitely better, right? And there was some of that after World War II with respect to art stolen from Jews and stuff like that, where it was quite clear that these works of art would still be in the hands of these people, right, from whom they were taken, and we knew who took them, and we knew how to get them back to the people, right? Over time, that becomes much harder to do. So one has to establish that the claimant really is worse off because of the sequence of events that have led up to somebody else being the possessor of something which is valuable to possess, right? The possessor doesn't have to have intended the wrong to be required to give it up, but the possessor has to be shown to be a beneficiary of the wrong, right? And so to have all that is really, really hard. I'm going to say now something maybe against the grain. There's a premise in a lot of these discussions that great injustices done to one group of people have been enormously beneficial to other groups of people. And that's a really uncomfortable premise for a classical liberal because it suggests, hey, if you really want to benefit yourself, find a big injustice to do to somebody else, right? The typical person in the northern states would have been much better off had slavery not existed in the South, because the South would have been vastly more economically vibrant, and there would have been much more opportunities for mutually beneficial interaction, right? So I'm not making a case one way or the other, but I'm saying that to make, I think, a strong case for certain types of reparation, which go back hundreds of years, involves many, many difficult premises. One more, in Lincoln's second inaugural address, he talks about the blood that has been shed by men of the North making up for the injustice, right? And there's something interesting about that, right? 300,000, 400,000 casualties on the northern side in the Civil War, right? So if I'm a descendant of one of those people, and I'm not, and my life is less good than it would have been if my great-grandmother hadn't been widowed when she was 20 years old, right? You have to figure out how all this goes in. I'm not outlining a political program here or a party affiliation, right? But it's complicated. It's more complicated than people normally think, I believe.
How should we think about something like eminent domain?
Okay. You should think of it as almost always involving injustice. But I hesitate because there are special circumstances where the right that somebody has to something is what economists and lawyers call protected by a liability rule and not a property rule, right? If your property is protected by a property rule, then others, you just can't take it, right? But if it's protected by a liability rule, it's a weaker right. There, your right means that if somebody takes it, they've got to compensate you fully. And there can be special circumstances where what we might think at first is a right protected by a property rule really should be understood as protected by only a liability rule. And so, again, it's complicated, right? And there are cases in which people's rights are connected in certain ways. So my son, who's a lawyer in Colorado, tells me about what happens when there are two people who have land next to each other and there's a pool of oil below their land. It's a single pool. If once the person starts pumping out, he's actually also pumping out some of the other person's, right? Does the other person, in virtue of his right, have a right to forbid the first person from pumping any of his oil out? Well, that seems wrong, right? But if you allow that person to pump, he is doing something to the, so some sort of an accommodation has to take place. And there's very clever laws about this, about how the profits are split and so on. Yeah.
What should we do for those in our societies who lack sufficient property for a minimally decent life?
Yeah.
Folks who might be dependent on charity, let's say, to meet their basic needs.
Right. Well, I'm all in favor of charity, so people should be charitable. And there are all sorts of ways that people can, who are in dire straits, can interact with one another in self-help organizations, and those are unfortunately discouraged. My own view is that that if people are in dire straits through no significant fault of their own, they are morally free to take that loaf of bread that's cooling on your windowsill and eat it. And that's not a violation of your rights. That there's a sort of primordial right of necessity. And if you're in this necessitous condition, not through any significant fault of your own, you do have a right to take that. And the fact that that would be very discomforting gives people with those loaves of bread a really good reason to have a bread distribution center. So people can go there and you don't have to worry about somebody showing up at your house or saying, you know, I need a place to sleep. I hear you have an extra bedroom, right? So this is another respect in which someone might, thinking about what I've just said, see that I don't think that rights are absolute, but I wouldn't put it that way. I would say rights are complicated. And when there seemed to be a type of conflict between rights, one has to think more carefully about exactly how to characterize the rights so that it's not just a matter of one person's rights somehow overriding other people's rights.